get us recording, and we should be ready to get underway. Fortunately, unlike round one of this hearing last week, we're not in council chambers and having to deal with all the technical difficulties down there. So having said that, now Zoom will glitch on me for the first time in a long time, but hoping that's not the case. All right, so I'm going to go ahead and call us to order at this point. This is a hearing before the City of Tacoma hearing examiner. It is essentially kind of round two to what we began last Thursday with a public hearing on the plat for the preserve. And we also had under consideration at that point the accompanying permits, accompanying other permits for this development, which were a critical areas minor development permit and also a major modification to the existing PRD overlay that exists at the subject property already, but is the intention for developing is different enough at this point now that a major modification was needed. And then also with a PRD, there's supposed to also be a site plan approval, but in this case, it wasn't just a site plan, it was the plat. The plat kind of subsumed the site plan, so we had that aspect in there too. Uh, less than 2 full days before that hearing was scheduled to be held, we had an appeal of the MDNS because that's when the appeal period closed. And the city's council was unavailable to go last Thursday to have the MDNS appeal aspect of the whole gestalt of what we're considering on this. And so I continued until today for the MDNS appeal to be heard. That was done under protest from the applicant, Copper Ridge LLC, and that was noted. It was done under protest, and it's on the record and everything for whatever that means for whatever comes after this. So let's take appearances from the parties, then we'll talk about how we're going to proceed today, and then we'll proceed. Let's go applicant first. For the applicant, who do we have present today for the record?
Thanks, Mr. Examiner. This is Heather Burgess with Dixon Froelich, Phillips Burgess PLC, appearing on behalf of the applicant as to the SEPA appeal portion of this proceeding. Thank you.
Thank you. And for the city?
Good morning, Mr. Examiner. This is Steve Victor with the Tacoma City Attorney's Office, appearing for the respondent.
I am not going to go through my usual recitation of authority and all that because that's on the record from the prior hearing. We have both parties represented by counsel today. I assume you know what's what, and I don't have to inform you of that like I normally do in quite a bit more detail when we have pro se parties and we have members of the public here who hopefully that information is beneficial for. I will note today for the MDNS appeal, pursuant to the Tacoma Municipal Code, oh gosh, off the top of my head, I think it's 1312-820 that deals with these appeals. The applicant challenging the MDNS has the burden of proof. And so my inclination is to do like we would normally do in most proceedings where the party who has the burden of proof would go first and last. I will note that under the TMC, which basically adopts the provisions from SEPA, well, I'll just read the language so I don't mess it up. And this is from court decisions on that interpreting SEPA primarily, but the agency's decision on an MDNS, and the decision to issue an MDNS, including what's in it, is afforded substantial weight. So that also factors in to this today. And I think given that the applicant bears the burden of proof anyway, by a preponderance of the evidence, according to the hearing examiner rules and our code TMC 123, I'm inclined to have the applicant go first. Does that make sense for the parties? The only reason that it wouldn't make sense to me is that in a SEPA situation like this, the city essentially has to establish a prima facie case somewhere along the way too. And I was mulling it over last night thinking maybe it made sense for the city to go first to establish that and then have the applicant take its turn at attacking it. But I'm more inclined to let the applicant go first in this case, but I'd like to hear from the parties whether you have any thoughts in regard to order of presentation today. Ms. Burgess, do you have any thoughts on that?
I don't. I think either way is appropriate for the reasons that you stated. Mr. Victor and I have conferred, however, prior to today's hearing regarding the issues presented on the appeal, and it's my understanding that the city wanted to make a record on one of the issues before we embarked on today's proceeding, which might make more sense for our presentation for that to happen prior to the applicant beginning. Thank you.
Okay, so let me make sure that I'm hearing you correctly on that then. Is the city just wishing to be heard on a particular aspect of one of the issues, and then we would go into presentation of cases, or would the city be presenting first in its entirety?
Mr. Examiner, we would consider this a preliminary matter,
Okay.
which wouldn't ultimately, it will affect what we talk about today, but wouldn't touch the order of presentation. So it's
Okay.
a truly preliminary matter.
All right. So let's do it that way then. We'll hear from the city on that, and then we'll go into presentations. I will note that we had separate submissions in the intervening week from the first round of the hearing to today. And so we do need to deal with that. At this point, what I have is submissions from the applicant that have 3 exhibits that have been marked A1, A2, and A3. There's a CV for Mr. Van Aken. There's a figure and then some photos. Is that the full extent of additional submissions from the applicant?
That's correct, Mr. Examiner, although we also did submit, just because the city had submitted one, a slightly different variation on the statement of issues, but that was our only other submittal. Thank you.
Okay. And I've got the statement of issues from both sides. I don't necessarily consider those exhibits. So they're part of the record, but not as exhibits per se. And I presume, Mr. Victor, that you've got a copy of all of the applicant's exhibits, A1 through A3.
I did, Mr. Examiner.
Does the city have any objection to those coming in and being made part of the record?
The city has no objection.
All right. So, Ms. Burgess, I presume you want to move to have those admitted and made part of the record then?
Yes, please. Thank you.
They will be so admitted. And from the city, we had exhibits then that have been marked C1 through C8. Most of those, I believe, are already part of the overall hearing record from round 1. So I don't know that, well, the applicant wasn't represented by counsel first round. I suppose if there is an objection at this point from the applicant on the city's exhibits, you could go ahead and make your record on that. But most everything was already admitted kind of in the first round, although this is a little bit different purpose today. Any objection on those, Ms. Burgess?
No objection from the applicant. Thank you.
All right. And I guess they'll be admitted and made part of the record again because they're already kind of there. So we got somebody joining late. Get them in. All right. So at this point, applicants A1 through A3 and the city C1 through C8 are all admitted, made part of the record. Either side can refer to those during the course of the hearing. If there is something that was admitted last week that somehow becomes relevant today, that's not in the list of A1 through A3 and C1 through C8, I suppose we can address that. But at this point, that's what we're dealing with today, is the 3 and the 8. And as the parties are making their presentations, if you would like a particular exhibit shown up on the screen, let me know and I will share that up on the screen for you. Are there any other questions or preliminary matters besides the city's one we've already talked about that we need to address before we talk about the city's issue?
Not from the applicant, Mr. Examiner, and the person that joined is one of our witnesses, Craig Deaver, I believe. So
yeah,
he's a witness.
Is he kind of the chief for the witnesses of the applicant, or? Should I leave him on the screen or should I put him off until it's time for him to testify?
You can put him on. You can put him off. Our first witness is going to be Aaron Van Aken. Thank you.
Okay, so let's deal with the city's preliminary issue then. Mr. Victor, go ahead.
Mr. Examiner, after consulting with the applicant appellant's counsel and our staff, the city has determined to remove the cultural resources assessment condition mitigation. So we wanted to make a record of that today, and we will be removing that. The inadvertent discovery plan condition will remain, but the cultural resource assessment we will remove. So that's the preliminary matter.
Okay. And just for my understanding and to make the record perfectly clear for my purposes or whatever purposes, the inadvertent discovery plan, I don't think is something that can be removed necessarily under state law. If you're developing and digging and you discover something, that triggers a whole bunch of things that you really can't avoid without incurring some substantial risks, I suppose, if you're caught. But otherwise, the city's mitigation condition of conducting something in the absence of any discovery is going away, correct?
That's correct, Mr. Examiner.
All right. So for my clarification, then, that leaves us in the MDNS. The M part of that MDNS is simply traffic at this point, and there were two bulleted conditions in there. And just for my perfectly clear understanding, this maybe goes to Ms. Burgess as opposed to Mr. Victor, but is the applicant appealing both of those bullet points or just one of them?
The applicant is appealing the bullet point that requires the construction of the 460 linear feet of sidewalk from the north end of the project boundary to connect with Blueberry Park. By extension, there's related conditions. I believe it's condition 31 that shows up in the staff report that call for the construction of ADA ramps associated with those terminus points. And so there's some cross relationship. If the condition to build the sidewalk were eliminated, then we would also be asking for the condition 31 for the ramps, which at that point I assume would go to nowhere, to also be removed. But we are specifically appealing the requirement to construct the sidewalk.
Okay. So, and I had it wrong. There are actually three bullet points under traffic. And so it looks like it's just the third bullet point of the MDNS.
That's correct. They were all listed within the appeal document because they went together, but the actual construction requirement is the 460 feet of sidewalk, and that's what's being appealed.
Okay. All right. So the applicant is not actually, through its appeal, trying to get the MDNS down to just being a DNS because we're not appealing two of the bullets, just the one. Correct?
That's correct. We don't need to change the form of the document. Thank you.
Okay. Anything else that we need to address preliminarily? All right. In the silence and watching the shaking of the heads on the screens, make sure we note that for audio purposes. I think we're ready to go ahead and begin with presentation then. Ms. Burgess, are you wishing to make an opening statement?
I am not wishing to make an opening statement, Mr. Examiner. We can go right to witnesses.
All right. And you said we were calling Mr. Van Aken first, correct?
That's correct. And it's my understanding that he testified. This is a bit unusual for me because normally I'm not kind of parachuting in just for a portion, but it's my understanding from Mr. Mann and Mr. Deaver that Mr. Van Aken testified at the Plat hearing previously and was previously sworn.
He did, and he was previously sworn, but just, you know, because of the intervening time and because the magic sort of wears off over time like that, I'm gonna go ahead and re-swear him unless somebody thinks that's really just out of order today. So, Mr. Van Aken, there you go. Get your right hand on the screen. Do you swear and affirm that the testimony you're about to give as part of this hearing today will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, Ms. Burgess, you may inquire.
Thanks, Mr. Examiner. And just to be clear, as indicated on our witness submission, we are offering Mr. Van Aken as an expert in the field of traffic engineering, and his CV has been previously admitted as applicant's exhibit A1. Okay. And I believe, Mr. Examiner, you said you wanted to control the display, correct, with the share screen. Would it be possible to show our exhibit A2, which should be a color Heath and Associates non-motorist connection figure?
So I'm showing the cover page here just so everyone can see that it is in fact exhibit A2. And then we'll scroll down. And let me just reduce that a little bit so we can get a little bit more of it on the screen all at once. There we go.
Just want to be grateful that you're doing that instead of me. So thank you, Mr. Examiner.
No problem.
Saves a technical step associated with it. Okay, Mr. Van Aken, did you prepare this exhibit?
I did.
Okay. And would you please kind of walk through for the hearing examiner what this exhibit shows and is intended to show?
Sure. So this shows the existing and proposed non-motorist infrastructure. It does not show all the existing or the proposed sidewalk internal to the site. It mainly looks at the frontage on D Street and 80th, which in red shows the sidewalk that would be constructed with the frontage improvements. In the magenta, it shows the soft surface trails that would be provided. At the north end, there's a 5-foot east-west connection that would continue off into the wetland area. And north-south, I believe, is going to be around a 12 feet or a 12-foot wide path. And those extend and would connect up to an existing trail to the Blueberry Park, which is shown as a dashed black line. In the middle of the site, there is an east-west blue line, which would be a shared use path. And at all the 6 intersections that are shown with the new ADA directional curb ramps, those would be ramps that would be on both sides of D Street. And I believe around 40 new ramps in total would be constructed. In orange, it shows the MDNS measure number 2, which is a 460 foot of sidewalk that would terminate at 75th, which has another public access to the park.
So up here where the cursor is now?
Correct. And then the green just shows existing sidewalk on the east side of D Street. The green dashed.
And so just specifically to make sure it's clear, the point of the project, where does the project specifically connect with Blueberry Park with a pedestrian facility?
So there will be a connection at the north end where the magentas intersect with the black dashed line, and through the Plat, there would be sidewalk connections to the magenta with the internal sidewalk, the shared use path, and the soft surface trail at the north end.
Okay. And then on the other side of D Street where your dashed green line is showing, you said that was a public sidewalk. Is that correct?
That's correct.
And does that extend up through and past where the MDNS measure 2 sidewalk would extend to?
It does.
Okay. Right, Mr. Examiner, unless you'd like to leave this up for your own reference, we're okay taking it down for purposes of the testimony.
Well, I can leave it up for my own reference here on my own screen without
That's
having to
fair.
subject all of you to it, and then we can get the larger screen of everybody participating. So there we go.
That's great. Thank you. So, Mr. Van Aken, are you familiar with the city traffic engineer's comments on this particular sidewalk extension that are discussed in the city's exhibit C3?
Yes.
Okay. And do you agree with the city traffic engineer's analysis that's found in this memo regarding the need for the sidewalk extension?
No, I agree with the intent to provide a connection to the Blueberry Park, which is achieved internal to the site. But in in my opinion, adequate connection to the park is being provided.
And when you say adequate connection, you're speaking specifically of non-motorized or pedestrian connection?
Correct.
Okay. Did you have anything else you wanted to add for the examiner's consideration?
No, unless there are any questions.
That's all I have
I
for
don't
this
have
witness.
any, so that's the scope of it then for direct with no questions from me. Mr. Victor, do you have cross-examinations for Mr. Van Aken?
I do, Mr. Examiner.
Go ahead.
Mr. Van Aken, you described that you felt the internal connection, which was depicted in magenta lines on the map, was adequate as a pedestrian non-motorized connection. Can you describe how a person within the development would follow that, would access that? And essentially, I'm asking what is between, if we follow the magenta line, what is between the development and Blueberry Park? What is the internal connection? Just give us a little more detail, if you would.
Are you asking how a resident may access the magenta line from the project?
Access Blueberry Park using the magenta lines.
Yeah, so at the terminus of the property, there is an existing, it appears to be a gravel surface for several hundred feet into Blueberry Park until it meets the paved portion to the north. And that looks like it's used today, and that would be the connection that would be used by the residents.
Is it along an established right of way, or what does the gravel way traverse?
I don't know if it's an established right of way. I don't believe it is, but I can't speak to that.
And I don't mean to belabor it, but it is not improved to ADA standards. The several hundred feet of gravel, is that correct?
That's correct.
Okay. Thank you. I have no more questions for Mr. Deaver.
Is there
Van
redirect?
Aken. Mr. Van Aken, I apologize.
Is there redirect based on the cross?
One brief one, Mr. Examiner. Mr. Van Aken, you just testified for Mr. Victor regarding the gravel path not being improved to ADA standards. You recall that testimony?
Yes,
Okay. The gravel path that you were speaking to, is that on the applicant's property or the existing condition on the city's property?
that is the existing condition on the city's property.
That's all I have.
When
Thanks, Mr.
we say
Examiner.
city property, we're talking Metro Parks, correct? The Blueberry Park.
Correct.
Okay, just to clarify, they are separate legal entities. Although Metro Parks District was created by the city, they are their own municipal corporation.
Yes. Thank you for clarifying, Mr. Examiner. That was the intent.
All right. That's all then on redirect.
That's all I have.
Let me just get some clarification for myself then for Mr. Van Aken on that point. So you're saying that from the subject property, it's proposed that there'll be you said soft surface path, so essentially a gravel walking path that goes through the preserve, connects up to Charlotte's Blueberry Park, where it is also a gravel path into the Metro Parks property that is Charlotte's Blueberry Park, correct?
Correct.
So in other words, it's not ADA compliant in the Metro Parks property either. Is that the point?
Correct. And, we would be constructing sidewalk on the frontage that terminates at the north end of the property, and that would be constructed to ADA compliant. So there would be an ADA path to the park property, but it terminates at the north end of our property.
And it doesn't go to the entrance then to the property, which I think was maybe the city's point, correct? Is that right? It terminates at the corners of the two properties where they join and doesn't go on to the entrance actually to the Blueberry Park.
Correct.
Okay. All right. Next witness for the applicant. Thank you, Mr. Van Aken.
Thanks, Mr. Examiner. The applicant calls Craig Deaver.
Sorry, I don't know if my mic was picking that up or not, but I apologize for my snorting dog there. All right, Mr. Deaver's got his mic on. Maybe he needs me to clear him for the video. If you could join us on the screen by video like you were earlier, that would be great. There we go. And I'm going to re-swear you in too. So if you'd raise your right hand, please. Do you swear and affirm that the testimony you're about to give as part of this proceeding today will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Go ahead, Ms. Burgess.
Thanks, Mr. Examiner. Mr. Deaver, have you had the opportunity to review the sidewalk improvement that's required by the challenged MDNS condition?
Yes, I have.
Okay. Could you describe for the hearing examiner some of the design and construction considerations associated with the construction of that sidewalk as currently required?
Well, yeah, we reviewed it, reviewed the requested improvement from the north end of our site to the entrance to the park. We currently are showing that there's approximately a 10-foot wide grass strip with a low wood board fence along the right that's delineates the right of way from the city's roadway system and the park for Metro Parks. We encountered and noticed that there is two street lights with a fire hydrant and multiple signage across the frontage that would have to be either relocated or accounted for in the design. In addition, we have stormwater issues. The requested improvement will generate over 2,000 square feet of new impervious surface. Therefore, that will need to be accounted for in the either in the city system or in our modeling for our on-site project. So the stormwater would have to drain across the existing grass strip and into the city curb line system and into the catch basins that are currently in East D Street. At this point, the concrete sidewalk would need some relief from city standards in order to make the actual location compliant with our frontage improvements, which would be the alignment with the 5-foot planter strip and 5-foot concrete sidewalk with some space behind that because of the constraints to the north of our site.
Thanks, Mr. Deaver. And Mr. Examiner, could I get you to show Exhibit A3, the photo, the one that's labeled where you can see East D Street from Google Maps?
On the way.
Thank you.
There's the first page after the cover sheet. Is this what we wanted?
Yes, it is, Mr. Examiner. Thank you. Mr. Deaver, just taking a look at this photo, is the area that you were just describing to the hearing examiner where the improvement would have to be constructed shown in this photo?
Yes, it is.
Okay. So could you just, at risk of belaboring the point, if you wouldn't mind just pointing out using the photo, kind of some of the issues that you just described?
Well, the low fence that is partially within the right of way and partially on the adjacent Metro Parks property. I don't know if I can control this. I don't know if I have the ability to control an arrow, but there's multiple signage, and at the south end of this picture, the far end of this picture down there, there's a street light. There's also a fire hydrant. There's some phone infrastructure or other communication lines that are in that strip. So there, and then on top of that, as we talked about with storm, you'll see that there's a catch basin near that red car there at the end of the site here that would potentially collect water from this sidewalk if required.
Thanks, Mr. Deaver. And Mr. Examiner, you can take the photo down unless you'd like to keep looking at it with everyone. Your call.
Good.
Okay. So, Mr. Deaver, based on all you described, how do those considerations impact the feasibility of the requested or the required improvement, if at all?
If this was implemented, we would need to design a sidewalk system that would likely require some meandering of the sidewalk around the existing features. It may require relocation of the fence that's either on Metro Parks and partially within the right of way. It may also require a relocation of communication systems as well. And
Thanks.
and I want to add street light as well. So sorry.
Thanks, Mr. Deaver. That's all I have for this witness, Mr. Examiner. Thank you.
Mr. Cross.
Just briefly, Mr. Examiner.
Go ahead.
Mr. Deaver, the ramps that we were viewing in the photos, do you know if those are currently ADA compliant?
The ramps specifically where?
In the photo that were depicted in the photo.
Likely they were not. We would
Okay.
have to survey them, but they did not appear to be, but I couldn't say definitively without picking them up in the field.
And just to, so Mr. Deaver, currently there is no ADA compliant path between the project and Blueberry Park. Is that correct?
To current ADA compliant standards, no. There are ADA ramps that were previously constructed on the east side of East D Street.
And I think you just testified those are likely not compliant. Is that correct?
That's correct.
Okay, thank you.
Is there redirect based on the cross?
I do not have any. Thank you, Mr. Examiner.
Okay. Next witness.
Thank you. The applicant appellant calls Evan Mann.
Good morning.
Good morning. Let me re-swear you in like I've been doing with everyone. If you'd raise your right hand, please. You swear and affirm the testimony you're about to give as part of this proceeding today will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes.
Go ahead.
Thanks, Mr. Examiner. Mr. Mann, have you had the opportunity to review the sidewalk improvement that's required by the challenged MDNS condition?
I have, yeah.
And as part of your position with Copper Ridge as the entitlement manager, do your duties include cost estimating, budgeting, and things of that nature for construction of your projects?
They do.
Okay. Have you had the opportunity to consider what the cost of this required sidewalk improvement might be, realizing it's an estimate at this point?
Yes.
Could you describe that for the hearing examiner, as well as what goes into your considerations in developing that estimate?
Sure. So while the request for the additional sidewalk seems relatively straightforward, it really fails to kind of gather all of the direct costs and peripheral costs associated with something like an improvement like this. So upon review of the likely walking path alignment, we estimate that this request could easily top $100,000 or more. Simply looking at the clear and grade and demo, probably in the neighborhood of $10,000 to $15,000, concrete sidewalk and subgrade prep upwards of $50,000. Stormwater potential impacts, we estimate could be anywhere in the neighborhood of 10,000. ADA ramps, again, as part of the Plat condition 31, ADA ramps on all four corners, which doesn't make sense since it's not a four-way intersection, of 75th would be anywhere from 20,000 to more, depending on what's required there. Asphalt repairs at that intersection could be anywhere between 10 and 15,000. Design and survey, 10,000. utility coordination and relocates could be pretty significant. So that we range that one anywhere between $20,000 and $70,000 just to relocate utilities. It's not insignificant when you have to relocate utilities. And then permitting, we anticipate could be anywhere between zero if it's connected to the existing work order, or $5,000 depending on what permitting may shake out of that. So and other right-of-way permits for utility relocates could be another consideration. So it's not an insignificant number. It's pretty major, and would be a cost to the project that would, again, be an impact to cost of the homes.
Thanks, Mr. Mann. And based on your role with the project, you've been on the project site and you're familiar with the property. Is that right?
Yes.
Okay. So there was some testimony earlier with Mr. Van Aken regarding the ADA accessibility to the park. You listened to that testimony?
I did, yes.
Okay. So could you provide a little more detail for the hearing examiner based on your familiarity with the property about how the ADA accessibility the project will provide connects to the park?
Yeah, so we're building full ADA compliant sidewalks on the west side of East D Street along our frontage. There is existing pathway that runs east-west on the park property directly adjacent to our northern boundary. So effectively, where our sidewalk terminates at the very northeast corner of the site, it is terminating at an existing path into the park. There are multiple access points to this park. I think there's 3 or 4 just along East D Street. So the most southern access point, which would be the most likely and common access point for anybody from our plat or anybody using the sidewalks that our plat develops, would be that southeast corner right next to where our sidewalk ends. So in terms of providing ADA access to the park, our sidewalk is ADA compliant and does terminate at the park, at a path in the park. So again, whether the park has ADA compliant paths in it or not, we have met our obligation to provide access to the park by way of an ADA accessible path.
Thank you, Mr. Mann. Mr. Examiner, I have nothing further for this witness.
Okay, so before I turn it over for Cross, I got to clarify a couple of things, and I'm going to share screen back up again. Pulling up A2. So I'm trying to make sure that I understood your testimony that you just gave here at the end correctly. And you can see my cursor here, the hand going all over.
Yep. Go ahead. Sorry.
Well, anticipation of what you were saying. I'll see if I can zoom here a bit, but let me ask the questions for just a moment, and then you can elaborate on whatever it is you have possibly here in just a second. So, and I'm going to try to get the key in here. So the red line is proposed sidewalk, and so there's going to be sidewalk, you're saying ADA compliant sidewalk in the red all the way along the frontage of the property, right?
Correct.
Does that terminate here though? Because it looks like we changed from red to orange right in here before we actually get to the corner points between the subject property and the Blueberry Park. It looks like we've got orange starting here.
So this just to be clear, this is a limitation of the mapping exhibit. You're seeing a break in the white to the aerial. That doesn't actually represent the property lines. The improvements, the frontage improvements, are required to be built to the extent of our property, right up to where our property ends, which is actually right where you're seeing that magenta line.
So this is the property line then here where we come across here.
Correct.
And so where the internal trail meets is actually right at the property line here. And
Correct.
this dotted dash is actually the property line And this white area here, this irregularly shaped, I don't know, I didn't do well enough in geometry to tell you what that shape is. This is all part of the Blueberry Park, even though it's white like the subject property, not like the aerial photo when we change over, correct?
Correct. Yes.
Okay.
Yes.
So this is the actual corner point between the Blueberry Park and the subject property here, and the red line goes all the way up to that terminus point where they join.
Correct. And just to be clear, that at that point where the magenta and the red line are proposed ADA compliant access point, there is an existing access into the park there.
Okay, and that was my question because I don't see that here, and you said there is one, so it kind of there's an access point, and you said it'll be an ADA compliant access point here at the corner into this heavily treed area.
So there's actually, so our sidewalk, the proposed sidewalk for the frontage will be ADA compliant and terminate at the edge of our property, which is also the edge of the Blueberry Park property. And there is a trail and an access point. I don't know, I don't believe that access point off of D Street is currently ADA compliant, but there is a trail going west into the park at that location. And again, there's a gap in their wood fence, and it's clearly an access point.
Okay, but you don't know for certain whether that's ADA compliant access, though. Is that
You know,
right?
I don't believe the trail off of D Street into the Blueberry Park is ADA compliant. I don't believe it is. However, our improvements connecting to that trail are.
Insofar as it's an ADA compliant sidewalk at that location.
Correct.
All right. Let's see if I can do this then. With the city's proposed mitigation condition, the extension of the sidewalk here in the orange, this comes down and terminates at an access point to the park, correct?
Correct.
Do you know whether that access point is considered to be an ADA compliant access into the park?
It is not considered to be an ADA compliant access. There's no curb ramp or truncated domes. It is just a curb and gutter, and then a asphalt paved path that terminates at the curb and gutter. There is, however, an ADA compliant access point to the north of here at 74th. So if one block further to the north, that the sidewalk on the east side of D Street passes in front of and essentially would be able to send ADA. So for instance, if an ADA necessary person was on the east side of D Street, they could travel just a little further to the East 74th access, which does have an ADA access onto the west side of D Street.
So a person would either have to cross somewhere down here, or when the sidewalk ends here, over to the sidewalk on the east side of the street, down to 74th, and then into the park in order to have an ADA compliant access.
Correct.
All right.
On existing sidewalks, yes.
Right. One more question for you then. You said that estimating right now, stormwater costs, construction costs, design, all of that for this additional length of sidewalk that the city is requiring at this point in the MDNS, you estimated a cost of around $100,000. Is that correct?
Yeah, again, rough estimate based on just experience developing in Tacoma, experience developing in the area, current projects and costs. Just looking at again length of sidewalk, approximate thickness and width. So it gives you some sense of how much concrete you'll need. Again, experience dealing with different utilities and relocating. Again, that's probably the biggest variable. You know, as soon as you get involved with Comcast, Lumen, Puget Sound Energy, Tacoma Power, those costs grow exponentially. So any streetlight relocation, any telecom pedestal that needs to be relocated, those are major costs that we have to account for. And again, it can be super variable.
So, and it sounds like, and I don't want to put words in your mouth, and I suppose if your counsel thinks that I'm doing that or calling for a characterization or a legal conclusion or something that she'd rather make an argument, we can do it that way too. But it sounds like that the applicant is saying, one, we're objecting to this condition because it's not necessary, we're already doing enough. And two, that at an estimated cost of around $100,000 for this, it's disproportionate to what we should be having to do. Is that correct?
That is correct, and I'm sure I'm sure our counsel will speak to that.
Okay. Um, would there be a cost if we were to continue to cut that $100,000 down to some point where it wouldn't be objectionable to the applicant anymore, or is it always going to be objectionable because the applicant's position essentially is we've already done enough without any of that sidewalk coming into play as a condition?
Yeah, I mean, obviously, if the cost was zero, we wouldn't object to it. We do feel like we've done enough, but is there a dollar figure that if it comes down to? I mean, obviously, again, if the hearing examiner feels like this must be done, then we would hope to have the opportunity to discuss ways to bring this cost down. But certainly, our position is that we provided access to and from that park in numerous public ways.
I think that's all I had then. Cross-examination from Mr. Victor.
Just very briefly, Mr. Mann, you testified that the existing entrance to Blueberry Park, that the MDNS would have the project connect to, that the existing entrance is not ADA compliant.
I don't believe so. Yeah.
Understood. I heard your testimony.
Yeah.
If you were to fulfill the condition in the MDNS and build the sidewalk to that entrance, would that entrance then become ADA compliant?
It would.
Okay. Thank you. No further cross.
Any redirect based on my questions and Mr. Victor's question, Ms. Burgess?
No redirect. Thank you.
Okay, let me just jot the note down quickly. All right. Next witness.
Mr. Mann was our last witness, Mr. Examiner. That concludes the applicant's presentation.
All right. So that leaves us moving to the city as the respondent here. And let's see, we're almost 10 o'clock. I would imagine at this point that, well, let's see where we're at time-wise when we get done with the city's presentation, or as we get into it, see whether we need a break at some point or not before that is all done. So, Mr. Victor, are you wishing to make an opening statement on behalf of the city?
I am not, Mr. Examiner.
All right. So, go ahead and call your first witness then.
Mr. Examiner, we would call Larry Harla.
And he's already on the screen with us. I presume you can unmute yourself, and you can. And so if you'd raise your right hand on the screen, please. You swear and affirm that the testimony you're about to give as part of this hearing today will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do, Mr. Hearings Examiner.
Go ahead and inquire, Mr. Victor.
Now, Mr. Harla, can you describe your position with the city of Tacoma and your relationship to this application?
Yes, I am a principal planner with Planning Development Services in the current planning division. And my relationship to this proposal is I'm the lead planner for the bundled application and the lead planner on the SEPA MDNS.
Thank you. Since we're really describing one mitigation, I'm not going to ask you a lot, or I guess arguing over one mitigation. I'm not going to ask you any general questions. What I am going to ask is relating to the condition that's challenged today. Can you describe how the issue that we've heard testimony on this morning of ADA connection, how that relates to the city's policies and land use requirements? And I'm going to inquire on the engineering side of our other witness, so you don't need to get into that if you don't want to. But I'm just trying to understand where the requirement that we're arguing today, how that relates to the city's plans and policies.
Yeah, so I'll try to answer that without going into extreme detail, and hopefully we can spare me of having to cite all the codes and sections with the accuracy I would like to in some sort of a written document. But there are many places. We start with a comprehensive plan that calls for connectivity to the existing grid work, and that's sidewalk and roadway. And of course, in a situation like this with an adjacent park, that 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 is a goal and a policy in several places in our comprehensive plan. That new development sort of meld and mesh with existing development in a way that is safe and convenient for the new residents and the existing residents. So that's one place. And then this is certainly embedded in many places in Title 13, and even I think we've provided both in the main application and also the exhibits provided for with the SEPA MDNS for this appeal. There are many sections, including sections in the PRD section of Title 13, as well as the Plat section of Title 13, that call for this same connectivity, that new development combined with the existing framework of the roadway and the transportation network. So, and that's where this condition, this mitigation, at least from the land use side of things, comes from. But I will stress that I guess I'll answer a little further. Like, this is an offsite condition, and so this wouldn't be caught up in the standard conditions for the project itself. So that's another aspect to this, and why this would appear as a SEPA mitigation. It's to mitigate an impact. But it's also supported by the I've already referenced our comp plan and our code. We have a specific way to condition it under our use.
You're breaking up
Thank
a
you.
bit.
I was going to say, is Mr. Harla breaking up for everyone?
Yes. It may be just a proximity to the mic kind of thing where you've got noise gating going on. So if you can get closer to the mic, that may help.
Okay, and I'll apologize. I'm actually off site today. I'm in a hotel room. So hopefully I'm coming through okay here?
You're sounding good for me, yes.
Okay. I don't know where I left off there. Did I cut out the entire time? Do you want me just to fully repeat?
No,
No.
you were discussing the relationship to the mitigation condition in SEPA and the relationship to the city's comprehensive plan and policies. And I didn't know if you wanted to just repeat that part.
Yeah, so I think you probably heard the first part. There's many places in the comp plan and in Title 13 that call for connectivity of pedestrian access and roadway access. And we don't have a specific Title 13 way to condition to mitigate this impact. And so that's why this appears as a SEPA mitigation, and it's not a condition.
Hold on with that a second. I was going to wait till the end to ask this, but since we've kind of said it twice now, I want to kind of interject. You talked about, there are provisions in the PRD provisions of the code and the Plat provisions of the code. In 1304 in the Plat provisions of the code, there has to be adequate provision for parks, for pedestrian access, circulation, all those kinds of things. And I'm not entirely sure that it couldn't have been required as part of that in order for there to be adequate provision for a number of those list of things, for park. I mean, because adequate provision for parks. Well, the preserve isn't providing a park or a playground or anything within its boundaries. So that has to be satisfied by existing facilities in and around within reasonable access to the proposed plat. Blueberry Park's right to the north. Access, is certainly a feature of that. So I'm not sure. I'm not sure I necessarily agree with you that it had to be thrown into the SEPA, but that leads to my question: is what is the environmental impact specifically that the extension of the sidewalk mitigates then? Because, like you said, there are all kinds of things in the PRD code, in the Plat code, that relate to parks, recreation, access, circulation, all of those kinds of things. But I'm still not clear, having read the MDNS, what the environmental impact is that this extension of sidewalk to that entrance of Blueberry Park is mitigating, per se. So help me out with that if you can. And if it's more appropriate for one of the other city witnesses to answer that question, that's okay. But I do hope the city will answer that question for me before we're done.
And again, I think maybe it's more appropriate for another witness to answer this more than me. I can just say, simply it's health, safety, and welfare, and of folks that are, trying to get to and from the park, and that the applicant in their presentation, outlined how they do have some connection to the park. So this is additional connection to the park. To answer the question about why don't we just leave it in the decision? I guess that would be my contribution to that answer.
Okay. Go ahead and continue then. Apologies for the interruption.
I have no further questions from Mr. Harlow, Mr. Examiner.
I didn't mean to kill it. I guess I was waiting till the end then, wasn't I? All right. So the cross-examination then for this witness based on what he's testified to in answer to Mr. Victor and myself.
Thanks, Mr. Examiner. Mr. Harlow, you testified about some kind of general policies related to connectivity to the existing grid work and things of that nature, right?
Yes.
So would you agree with me that the condition as it exists that terminates that sidewalk at the park pathway doesn't provide a broader connection to the entirety of the park? Meaning you can get to the entrance, but that's where it stops. That's not providing access throughout the park.
Could you ask that more precisely? It does provide access to the park. We don't have the ability to condition the applicant to do things into the interior of the park, if that's kind of what the question is asking. I guess I'm not understanding.
Sure, I'm happy to rephrase it. And I think you understood most of my question based on your response. So as this condition is imposed, the sidewalk connection terminates at the entrance to the park, correct?
Correct.
And within actually the park property itself, which is fairly large, there's nothing about the condition that would provide those who get to that entrance any greater access to use the park.
No, not in terms of the interior of the park. I mean, I would assert, since you've asked the question, that it provides another and arguably a much more convenient and maybe a safe access, particularly from about 65 of the lots that will naturally sort of follow the interior configuration to the roadway, and then perhaps prefer to use an improved sidewalk to get up to the park, particularly if it's a little dark. Maybe they want some lighting, that sort of thing. So staff would say that this is a convenient and better access, perhaps, for a good portion of the folks in in this future development.
Right, but can you point me to the comprehensive plan policy that talks about a requirement for a convenient or a better access as opposed to an adequate one?
No, there's no specific requirement in the comprehensive plan to that level of specificity, with really anything, not just for sidewalks.
Understood. And would you agree with me that I mean, in terms of, more convenient or easier access, you're aware that there's a paved sidewalk on the other side of D Street, correct? It's an existing sidewalk.
Yeah, correct. I don't want to over answer on this though, because I think some of this stuff we're getting into engineering territory. If I could sort of just remind everybody, myself included, to not over answer questions.
It's fair. Regarding specifically kind of the comprehensive plan policies and land use requirements, can you point me to a specific reference for ADA compliance as an environmental impact under SEPA?
And I will apologize for not having it memorized off the top of my head. I don't, we do throughout Title 13, do mention ADA compliant access. In the comprehensive plan, I cannot answer that we have specific language in the comprehensive plan about ADA compliant access, off the top of my head.
Thank you so much, Mr. Zavala. That's all I have.
Mr. Victor, do you have redirect based on the cross?
I have no redirect, Mr. Examiner. Thank you.
Okay. So thank you for your testimony, Mr. Harla, and we will move to the city's next witness.
The city calls Dan Hansen.
All right. If you'd raise your right hand on the screen, please. You swear and affirm the testimony you're about to give as part of this proceeding today will be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
Go ahead, Mr. Victor.
Mr. Hansen, can you describe your position with the city of Tacoma and your relationship to this, the MDNS for the preserve?
Sure. Currently, I am a grant coordinator for the City of Tacoma's Public Works Department. I've been in that position for approximately a year. Prior to that, I was a development reviewing engineer for the traffic group. And I was involved in the early phases of review for this project, including the pre-application process and reviewing some of the initial, plat layout, that sort of thing. I am a licensed professional engineer in the state of Washington also.
Thank you. With regard to the challenged condition, can you describe what impact that we identified as a result of reviewing this project gave rise to the condition that's challenged today? What were we looking at that caused us to decide that there was an impact that warranted this particular mitigation, the sidewalk connection?
Sure. The applicant submitted a traffic impact analysis with their documents for the permit submittals, and that traffic impact analysis estimated peak hour. I believe it was 24 peak hour trips of active transportation. So that's biking, walking, primarily walking tends to be the predominant of that type of trips. And that's just in an hour, right? This is 100 plus houses. There's a lot more trips, probably an order of magnitude greater. When you look at vehicle trips, it's usually at least a factor of 10 greater all day trips than your peak hour. So as part of it comes to the limitations of the data sets that are out there from the Institute of Transportation Engineers not having all day trip generation data for this specific land use for pedestrian and bike trips. So, 24 trips in the peak hour total. I believe approximately half, maybe a little over half, are projected to go north. I would have to actually double check that. I think, yeah, 5 + 7. So we got um, about half are shown going northward in the trip, and that would be the impact. Of course, of those many trips that are occurring every weekday, and of course on the weekends as well. A certain percentage of those individuals would be expected to have a disability. In this census tract, based on the city's equity index, we see a disability rate of 12%, and that data is based on the American Community Survey data through the Census Bureau.
So that's very helpful. And I'm tempted to sort of try to say it in non-engineering, but I can't testify. It sounds like a lot more people, let me say, am I correct? A lot more people, significant number more, and significant disabled number of disabled people are likely to want to access the park from this new housing development. Have I heard it correctly?
Yeah, I think that's the impact that we're looking at mitigating. The park would definitely be among the most, well, it would be expected to be one of the primary pedestrian or active transportation destinations for some trip originating at this site that's being redeveloped.
Okay. And we've already gotten, so let's see. There was testimony that from the applicant that providing an ADA compliant path to an entrance to the park, which would, by fulfillment of this mitigation itself, become compliant, wouldn't ensure ADA compliance within the park. Are there ever circumstances where we're able to require, metro parks to internally make ADA compliant improvements to their parks that you're aware of? That's a really compound question, Dan.
Right. I would say when Metro Parks redevelops one of their parks, that would be a time when we can require it. When somebody else is doing a development, or when the city, say, is redoing a road adjacent to a park, we would not be going and changing things internal within the park. At least not typically. There would likely be an interlocal agreement or something of that sort if that was going to happen.
Okay, thank you. That's a really good answer to a really poorly worded question, so I appreciate that. Was there anything else that you heard today from the testimony of the applicant's witnesses that you wanted to respond to?
Yeah, I guess I'd like to just speak to a little bit the fact that there is a sidewalk on the east side of D Street, and kind of why that sidewalk may not fulfill the needs of the community and may not mitigate the impacts of this development in the same way that the MDNS condition would.
Okay. I appreciate that. Okay, I have no further questions
with that, or should?
Oh, please, Dan. Yes, I'm sorry.
Okay, yeah, I was just.
I think he just framed it up for what he was coming with next. So let's hear the next.
Okay, so, and I believe Larry spoke to the fact that there's, 55, maybe 65 lots that are either fronting on East D Street or, just around the corner, essentially in the development where East D Street is clearly going to be more a direct route than, traveling out of direction to go to the soft surface path at the back. Even if you say we're an individual with no mobility impairments whatsoever. It would still be direct to go to D Street and reach the park that way. Now, when we look at the other side of the street having sidewalk, that does require, crossing over the street, walking on that sidewalk, which we've determined, based on the exhibits, the photo of the street was almost certainly not ADA compliant on that other side of the street. And then you would have to cross the street again to get back to the park. So again, that would be a bit of out of direction travel. Pedestrians, typically are very sensitive to the most direct path to get to a place. And so, in that sense, we would expect potentially people to look for alternatives that don't require that, which might be, might lead to a more higher likelihood of people walking in the street where they would, mix with traffic, potentially a safety concern with that. Having that sidewalk connection to the more developed portion of the park, which is further north when you get to the asphalt pathways, really avoids some of those potential impacts. And I think that's the second thing that we really haven't discussed is that this park kind of has a northern portion and a lesser developed southern portion. The northern portion is where the community garden is, it's where the playground is, and it's where the asphalt paths are. And so by having that accessible connection to the asphalt paths, there's an accessible, safe route that gets to the more developed portion of the park that's likely to generate more pedestrian trips and more interest from the community.
Thank you. I have no further questions for Mr. Hanson.
All right, thank you for your testimony. Actually, before we let you go, I want to ask just one clarifying question. You talked about 24 peak hour trips that will result from the development. That's including pedestrian and motorized everything up and down D Street, correct?
No, that's the generation of only walking, biking, and transit trips.
And by transit, you mean bus?
Yeah, so that would again be another walking trip because it would just have a walking to the bus stop. So certainly on this segment, any transit trip could also be included in that. The statistical, manual that it's drawn from doesn't break it down by those individual ones. There might be in the data sets some more variation. There might be some, but in any case, when you see the walk, bike, transit, you can assume, it's significant majority is walking, probably. I don't know. I can't say based on data anything, but I would guess it's 80% or more. Just knowing just general traffic, breakdowns. I would expect it to be over 80% of those are walking. I believe let's see, 76 is the PM peak hour for vehicles from the TIA, 76 trips. So quite a few more.
Okay,
with
so
vehicles.
and that's separate and apart from the 24 that you referenced.
Yeah.
Okay. All right. That's why I asked it. I'm glad I did. So that helped clarify.
And I suppose the vehicles would be, a secondary impact if we were worried about pedestrians potentially walking in the street without this mitigation. So
well, that's sort of the city's Project Zero, isn't it? The whole concern about interaction and
Mhm.
the unfortunate interaction that we have sometimes between the vehicles and the pedestrians, and trying to reduce that, if I'm
Yep.
not mistaken. So, all right. Thank you for that clarification. I'm glad I asked. City's next witness.
Mr. Examiner, has Ms. Burgess had the opportunity to cross Mr. Hanson?
Indeed, I have not.
Oh, okay. So my apologies. We were still getting to that point then. Cross-examination then for Mr. Hanson.
Thanks, Mr. Examiner. Would you mind showing once again for so I can address it with Mr. Hanson, exhibit A2?
Yeah.
Thank you.
Right.
Thanks, Mr. Examiner. And maybe scroll down just a tiny bit would be great. Thank you. Okay. Mr. Hanson, you've been present throughout the moment or throughout the morning, correct? So you saw the prior testimony and had an opportunity to hear the testimony about this exhibit offered by the appellant. Is that right? Okay, great. So I just wanted to, you testified that, and I'm getting echo, and I don't know if it's me.
Yeah,
I'll mute my mic.
I'm hearing it too.
Okay, great. Thank you. So, Mr. Hanson, you testified, I believe, that in response to questions from Mr. Victor, that the impact that this MDNS measure is directed to is the 24 peak hour non-motorized trips, the walking, the biking, the transit, realizing they can't be distinguished. Is that accurate?
Partially accurate. I would say it's all of the trips that occur over the full 24 hours. We only
Sure.
have data that estimates the peak hour.
Understood. So but you're specifically tying this improvement to the impacts that were documented in the TIA, if I understand your testimony.
I may need to look at the specific MDNS condition and whether it ties it to anything beyond the TIA. I guess I could say that I've provided testimony only to the impacts of the TIA, and I assume the MDNS is entered into the record. So I guess I won't speak to whether or not that's the entirety of what the city's, position is.
Sure. So that's fair. So specifically looking at where those pedestrians, these new pedestrian trips coming from the project specifically, speaking to where that they can access the park. So if you're familiar with this exhibit, the project, would you agree that the project's providing a connection at the northern boundary internally, right, on the magenta line to the existing Blueberry Park Trail? There's a connection there, right? And then there's full sidewalk improvements along the sidewalk frontage that connect to the other magenta line, the east-west line that's shown here, which is another access to the park, correct?
There would be full sidewalk along that frontage up to the northern property line.
Correct. Connecting to that southern entrance to the park.
I guess I'm not certain exactly how that will be designed in that area. I feel like I would need a little bit more, accurate survey to say whether or not it connects. But I can say that there is, a type of entrance at that portion of the park. When looking at street view photos. I haven't visited there recently, but it's a less developed entrance. I don't know if it's primarily for vehicular use for maintenance vehicles or if it's developed as a pedestrian walkway but it's kind of a grassy, gravelly looking thing from what I've seen.
Okay, but in terms of what the applicant is constructing.
The applicant is constructing a ADA compliant sidewalk along the red line, and it reaches a point where you can access the park through some level of development, grassy to gravelly trail.
Okay. So, and then if folks from the development cross the street, they could also access a sidewalk that goes north and south on East D Street, correct?
Correct.
Okay. So to the extent that the issue is, safety associated with crossing East D Street, would a crosswalk address that problem? Because I understood you're talking about competing trips and people walking in the street. So nothing about this condition speaks to a crosswalk. Would a crosswalk be adequate?
A crosswalk wouldn't address what I was talking about when I said the directness of the route is often very important to pedestrian wayfinding. It was because it would still require two crossings of the street. The applicant will be improving unmarked crosswalks by developing, curb ramps at all of the public intersections as they spoke to earlier. So, in terms of a marked crosswalk, we've determined that those intersections didn't need to add marked crosswalks, I believe. At least I didn't see it in the conditions. So no, I don't think a marked crosswalk would change the issue of route directness and that sort of thing.
Understood. Can you speak to any objective criteria that are used to assess route directness, like how many linear feet is considered direct or anything of that nature? Or is it just a subjective determination of what a traffic engineer such as yourself or Mr. Van Aken, for that matter, believes a reasonable pedestrian would do?
I'm not aware of an objective measure that would, speak to how pedestrians would react to a route that's 20% longer versus a 15% longer, for example. So there may be research out there, but I'm not aware of it.
Okay. And then I think your testimony, you addressed kind of the improved, if you will, areas of the park, kind of where the paths are, and the community garden are in the northern portion of this park. Is that correct? I didn't hear your answer, Mr. Hansen. I'm sorry.
Oh, sorry. Yeah, I may have unmuted a little bit too late. That's correct.
Okay. So you would agree, wouldn't you, that no matter what connection is provided, the portion of this park that's closest to the project is the unimproved portion. And to get to the improved portion of the park, all of these folks, regardless of route, are going to have to walk at least far enough north to reach that. So there's still a distance involved to get to the improved portion of the park, regardless of if they take the internal path or the sidewalk across East D, or even get there halfway using this new sidewalk that's required. Would you agree with that? I'm sorry, I didn't hear you again. I don't know if it's just me.
Sorry, I'll lean in a little closer. Yeah, I would agree that there is still a distance that needs to be walked beyond the north end of the project to get to the developed portion of the park.
Okay. And you're also testified regarding the percentage of those in this, forgive me if I didn't catch it correctly, this census tract, is that accurate, with a disability rate of 12%? Do you recall that testimony? I'm not hearing you again. I really hope it's not me. Okay.
Not just you.
Okay.
How about now?
That's better. Thank you.
Right, I'll try and just reduce the volume so that we don't get the echo, but I'll keep myself unmuted because clearly there's a lag in unmuting process. Apologies.
Yeah. That's okay. And the echo problem went away. So it's much better to hear you for sure. So thanks, Mr. Hansen.
Okay.
So in terms of that 12% number, then, is it would it be your expectation that of the residents in this new development, that 12% of them would also reasonably be assumed to be disabled?
Yeah, I would just say that over time, you would expect this development to probably be similar to the rest of the neighborhood. I don't know though. I mean, it's a slightly different, you know, characteristic, slightly different type of housing stock. So I guess I don't know how that would affect the disability rate. I think, you know, what's I think what I'm trying to get at with the 12% is that there's going to be a percentage that we see in Tacoma, and it tends to be, between 10 and 20% of people have a disability when you look at the numbers at the various census tracts. So I think we would expect certainly over time. I don't know if new residents are likely to be a lower percentage of disability than long-term residents, right? And so when people are just moving in, it might depend on the type of housing stock, but as people age and have lived there for a few decades, those numbers may change, right? And so, yeah, I can't say it would mirror the neighborhood on day one when everybody moves in, but we would expect over time that a certain percentage of the people who live there would have disabilities.
Right. And if I understand correctly, that then would be relevant to the need for the project as a project impact, right? To be providing disabled ADA type access to these facilities. Is that correct?
Not entirely sure what
So you testified regarding,
rephrase.
sure, you testified regarding the percentage of folks that are expected to have disabilities. Presumably that testimony was offered related to the access that's in dispute here, right? The need to provide ADA access. Is that or am I misinterpreting
Yes,
why that was offered?
yes. So the reason why that was offered is that, the TIA, the traffic impact analysis, identifies an impact of pedestrian trips. We would expect a certain percentage, we can't say the exact number, but a certain percentage of those trips would be taken by individuals with disabilities. That is the entire intent of that there is an impact.
Okay. So what
Same
you
with trips.
testified, I believe that you were involved as a development review engineer in the early phases of this project. So were you aware that this is entirely a townhome project and not single family residential in the traditional sense?
I believe that the point that the plat was changed to have the current number of lots, I was aware that it was townhome.
Okay. Would it surprise you to learn that none of the townhomes are going to be constructed with ADA accessibility?
No, that would be surprising because I know there is, um, an exemption for single family housing, right? Where you don't have the same requirements that multi family housing would have for ADA. But I guess that's beyond my area of expertise because we're talking building code and that sort of thing. And I'm a traffic guy, so it's probably shouldn't. I guess, am I surprised? Probably not, but it's definitely not in my wheelhouse.
Okay. So if we're looking back to the specific impacts of the project, if we just assume for the sake of this particular question that none of the units in the project are going to be ADA units, then would we still expect the same percentage of disabled people needing ADA access to be using these pedestrian facilities?
I would expect some percentage of people with ADA access needs to be residents, even if they weren't originally built with accessibility features. I would assume that many of the existing single-family homes of the area were not built originally with ADA access features, and yet people live in them for a while, and through injury or aging or other events that occur in life, acquire a disability. And so I would expect that the housing stock being constructed here would function similarly, and that you would have a disabled population living there over time for sure.
I think that's all I have for Mr. Hansen. I greatly appreciate your time, Mr. Hansen. Thank you.
Is there redirect for Mr. Hansen?
I have no redirect, Mr. Examiner. Thank you.
All right. Now the city may call its next witness.
The city has no further witnesses, Mr. Examiner.
Okay. We're getting a little bit of echo again there from somewhere, but it's not the worst I've had. So the city has arrested then, as I pointed out at the outset, and as the attorneys I'm sure already knew, the applicant bears the burden of proof in its challenge to this one bullet point of the traffic mitigation conditions listed in the MDNS. And so the applicant has the opportunity for rebuttal testimony. And I guess before I decide what we're going to do next, I will ask if there is rebuttal testimony from the applicant at this point. And depending on the answer, I'll decide where we're headed next.
The applicant does not have any rebuttal testimony to offer, Mr. Examiner. Thank you.
Okay, so with no rebuttal then, unless I'm missing something, as I almost did earlier today with the cross of Mr. Hansen. Thank you for the reminder on that. I think that brings us to closing arguments then, unless I'm missing my guess.
That's where I think we are, Mr. Examiner.
And I saw the city also nodding heads there.
We agree.
Okay. So given that, I don't think we will take a break. I think we'll just go ahead and push on through. I'm not anticipating closing arguments of the type that I've occasionally had to sit through, not as the hearing examiner, but when I was playing the advocate role. I'm anticipating closings being more along the typical length of around 10 minutes apiece. And so what I would like to do is just push on through and finish things rather than taking a break, even though we're at 10:30. And unless the parties were wanting to somehow go on a very, very lengthy closing argument, I think let's go ahead and do that. And we would go into the order we've already established: the applicant, then the city, and then if there's rebuttal closing briefly from the applicant, we'll do that. Then we have a couple procedural issues to address still, relating not only to this hearing, but to the overall hearing at this point. And we'll address those and be done. So, Ms. Burgess, go ahead.
Thanks, Mr. Examiner. With not wanting to disappoint you from not presenting a live closing argument, what I'd request is the opportunity to have a couple of days to submit our closing argument, legal argument in writing. I discussed this with Mr. Victor, and I understand that the city has no objection, and the applicant also doesn't object to kind of a simultaneous submittal. So I'm not looking for a serve and volley type situation, just a couple of business days to put that together and have it submitted. Given the size of the project, it didn't seem that would be unduly burdensome, but if that's an issue for the examiner, of course I understand.
It is not. It's not an issue at all. That's perfectly fine, and especially where the parties have had the foresight to discuss that ahead of time and are agreed on it. I absolutely have no problem on that, and I actually prefer that when written closings are submitted, that they come in at the same time rather than being we'll do ours and you respond, then it comes back. That just lengthens the process, really, in my view. In some cases, it may have some utility, but I'm not seeing it here. And since the parties have already agreed to just submit them at the same time, I'm perfectly fine with that. So both parties submitting written closings then? And how much time did you think you needed for that?
I don't think Mr. Victor and I discussed a specific time frame. Applicant can be in by Tuesday, the 22nd, but we're not opposed to going a full week if Mr. Victor prefers an additional couple of days.
I'm okay either way. Just all it means is, you know,
I can accommodate any schedule. Next Thursday would be wonderful, just because of the other things that I'm involved in. But I can accommodate any schedule that meets the applicant and the examiner's preference.
I'm okay with next Thursday if that's what the parties would like.
Works for the applicant.
Okay, so let me just slide windows around here just a little bit. Next Thursday would take us to the 24th. Please have those in by close of business, if you would, please. Electronic submittals are fine. So type it all up, sign it, scan it, shoot it in by an email to the hearing examiner email, and that will work just fine. Is that what we're agreed on then? Okay. So let me switch over to my emails here for just a moment. At the end of round one of the hearing, there were a number of proposed conditions from the city staff report that were being contested by the applicant. And so what I told the parties at that point was, you have another week to keep talking to see if you can reach some agreement on those. And in the absence of that, I want the city was going to submit something in writing regarding those conditions, and I guess sort of in defense of those. And I think the city has done that. I got a submission from the city today. I've not had the opportunity to review that yet. Mr. Harla, I'm assuming that just in good form, you sent those out to the applicant as well. Is that correct?
Yes, Mr. Hearings Examiner, I sent those to the applicant and to your office as well.
Okay, and I think I read something somewhere in that transmittal of it, or maybe my office staff characterized it that way this morning after you called and spoke with Ms. Legg, Mr. Harla, that there was maybe some agreed upon revision, but that the city and the applicant couldn't reach agreement on all of those contested conditions from round one of the hearing. And so the city is just submitting then its position on those at this point. Is that a fair characterization?
Correct, Mr. Hearings Examiner.
Okay, so given that there was some agreement, where there is some agreement, in all likelihood, I will adopt that some agreement on the portion of what was agreed to in terms of maybe revising or doing whatever. And I don't know what that is because, again, I haven't looked at it yet. But that where there is still disagreement on that, I told the applicant that the applicant would have the opportunity to respond in writing then to what the city submits. And that's still going to happen. I said the applicant has the last word on that because the applicant bears the burden of proof. So the city's made its submission at this point. What I would like to see then is on those conditions from the plat and other permits portion, round one of the hearing that I'm calling it at this point, the applicant submit those at the same time as the written closing argument is submitted next week. The city had a week, the applicant will have a week. The applicant will submit its response to what the city submitted today. Next Thursday, close of business, same time as the written closing argument, and then that will close the record completely at this point. Does that work? I'm seeing head shaking.
Applicant, yep.
Okay, so there we've got an audible from Mr. Mann.
Yes, thank you.
The city, that works too.
All right. Okay, so not that I won't be working on things up to that point, but given that the record isn't officially closing until next week, that's when I'm considering, sort of the official period of of my writing and issuing to begin at that point, and so I will do that. But I'll be working on what I can prior to that point. I will note that given everything that's transpired today, I think I'm probably going to make a site visit. Per hearing examiner rules of procedure, site visit is not evidence. It's not it's not anything that comes into the record other than that's just in my mind at that point of actually being there. Site visits, as are outlined in the hearing examiner's rules of procedure, are just simply to help me visualize and understand the actual evidence better at that point. And I think I'm going to make one. I will probably do that tomorrow. I don't see a need for the parties to be present or accompany me on that. If the parties feel differently, you can let that be known now. And whether I conduct a site visit or not will be referenced in the decision that ultimately issues on everything. So I don't think I have anything else procedural at this point. If there are questions from the parties or other procedural matters that need to be addressed, let's get those out of the way, and then we'll be off the record and done for today. Anything from the applicant at this point?
Mr. Examiner, I don't think so. Not having been part of the earlier proceeding, I don't know from Mr. Mann if there's any security or anything on the property that would, I don't know what site, where Mr. Examiner wants to go on the site, but I'm not aware of any restrictions, but just if there was an access concern, I wanted to make sure that that was accessible. Thanks.
Yeah, I'm not planning on going on. Most of what I want to see, I think, will probably be able to be seen from public right-of-way areas. So I'm not looking for that. I'm not looking to trespass or gain, authorization to go on.
No trespass suggested, just making sure it was open and accessible when you wanted to get there.
It is open and accessible, and you're welcome to go on site. I would say beware that there has been historically and continues to be a problem with transient activity. So we're use caution.
Yeah. Yeah, and I think the things that I'm intending to be able to view more have to do with things from today as opposed to from round one. So less internal to the site, more external, along frontage and access points and things dealing with what is and isn't available in terms of access to the Blueberry Park. So, any questions or procedural matters from the city?
None, Mr. Examiner. Thank you.
Okay, so I will look forward to those written closings. I will go over what the city has submitted today in regard to the conditions from round one, and then I will see what gets submitted from the applicant. Certainly the applicant can submit things before next Thursday in regard to those conditions, but you have till next Thursday. I'll give you until then. So. And then we will get decisions out. One last thing though that has crossed my mind, and I'll just give the city the opportunity on this. I asked a question in round one, where this is a major modification to a PRD, whether I am the decision maker on the major modification or whether sort of in reference to language in the TMC that says when it's a major modification, you basically go through the process all over again, whether that decision gets submitted to the city council or not. And Mr. Harala said that it was PDS's opinion that major modification is in my hands and doesn't go back to the city council. And were it not for the PRD major mod being attached to the plat that requires a public hearing and therefore then comes to me to decide at first instance, that the director would have just decided, the PDS director would have decided the PRD major mod, and that's how it would have happened. And I've gone back over the code on it, and I'm still not sure that the code is crystal clear on that. So if the city would like to submit its authority for that proposition, I would certainly welcome that. I'm not requiring it, but if you do, that should come in by the 24th as well. Since I have brought it up again, I'd love to hear whether the applicant has a position on that or not, whether they think that it should just be me deciding it or whether I should just be making a recommendation, as was done when the PRD overlay was originally put into place on this. I didn't decide it. I just did a recommendation and it went to the council. So I don't know if the applicant has a position on that and wants to state it here, or whether the applicant would like to address that as well in some sort of submission prior to the 24th.
I anticipate the applicant would want to address that, Mr. Examiner, but I'm not prepared to do that right this second. So if we could do that with the materials on the 24th, that would be great. And or confer further with the city about the basis for its authority and see if we have an agreed upon interpretation. Thanks.
Yeah, if you have an agreed upon interpretation, you want to submit that to me, that would be great. Ultimately, I'm the one, I guess, who gets to construe the code on it, but I'd certainly love to have the city's positions on that spelled out a little bit more in detail than when I put Mr. Harala on the spot with that last week. So.
And that understood, Mr. Examiner.
And both of you having till the 24th on that is perfectly fine too. So that seems like enough at this point. Thank you for your presentations today. I will look forward to your submissions on the 24th, and then you can look forward to me issuing a whole bunch of stuff. So there you go. And with that, I think we're ready to go off the record, and I wish you a good rest of your day.
Thank you.
Oh, I should mention, I don't know, at the end of round one or somewhere along, actually at the halftime point of round one, I think, I said that the video for round one would be put up onto the hearing examiner playlist in the city's YouTube page. And it took me a little longer to get the assistance that I needed for that because it wasn't entirely in my hands to post that, but it was up as of yesterday, and I will try to get round two here today posted up as quickly as I can so that if people are wanting to go back and re-listen to that, rewatch the Zoom video, whatever, it will be on there. Round two is up. Just want to make sure you know that. So, and with that, we are concluded. Have a good day.